5, Court of Appeals Division 1 is now in session.
Thank you. You may be seated. Good morning. We're here today. Our case number CA IC150026, Alejandro Chavez versus the Industrial Commission of Arizona. Each side has 20 minutes. Petitioner, you'll be responsible for reserving any time you'd like for rebuttal. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client when you approach the podium. We've read the briefs in this matter, and we've conferenced it earlier today. And with that, we're looking forward to your argument.
May it please the Court. Good morning, Your Honors. My name is Erica Gonzalez Melendez, and I represent Mr. Alejandro Chavez Ortega. I would like to reserve 5 minutes for rebuttal. The issue before this Court is a crucial one at the Industrial Commission. The reason for that is that many of our cases go through many twists and turns, and many different issues arise. Claim preclusion is one that continues to arise, and that clearly our judges, our administrative law judges over at the Commission need some guidance from this Court as to how to proceed in these matters. In the case at hand, as you've read, Mr. Alejandro Chavez sustained an injury on February 7th, 2011. His initial claim in his initial report of injury was for a left knee injury. He began treatment, and shortly after that, in August of 2011, Dr. Rothbart completed an independent medical examination at the request of the carrier. It is the petitioner's belief that this IME was crucial in this case. Crucial because that is what triggered claim preclusion. Claim preclusion, it applies to issues that could have been litigated. As you know, Dr. Rothbart's IME described not only the issue with the left knee, but also unequivocally states Mr. Ortega Chavez, or Mr. Chavez Ortega, has also sustained a low back injury, and it's related to the industrial injury.
Could have been litigated. Doesn't that mean as part of litigation that it could have been litigated? Why does that end up being claim preclusion?
Because at this point in time, when the carrier gets this independent medical examination, one of three things can happen. The independent medical examining doctor can say, okay, this is the knee, this is what's going on, this is the treatment that's required. He could have closed the case at that time. He could have said the low back is a problem, but it's not related to this injury. Or he could have said that...
Let's say the report said low back's also an issue. It certainly doesn't go to low back is an issue that we expect to continue indefinitely. Let's say there was we accept that the low back was affected initially. Why would that necessarily preclude someone from later on concluding that the low back isn't a permanent injury resulting from the accident?
Well, Your Honor, and that's not actually what's at issue in the case. At the end of the case, what Judge Nye says, and Judge, who is the administrative law judge in the case, is that the low back was never related. And that's what we have issue with, is that we have this IME at the outset of the case relating the low back unequivocally. Like, you know, he says he has sciatica. The left leg symptoms are because of the low back. At that point in time, There's no mechanism at the Industrial Commission, unless the carrier decides not to authorize the treatment, there's no mechanism for us to get a notice of claim status at that point, unless the carrier issues something, or issues a notice of claim status stating, no more, left leg only, or,
Doesn't that work to your client's benefit if the benefits are paid? If there's never been a legal proceeding, benefits are paid until someone, if at some point they say, well, it may have been partially related, but we don't think, we think that may have only been 1% related, and now there's a subsequent IME that says it's related to something else. Why? I guess I'm having a hard time understanding why it would necessarily be claim preclusion under those circumstances.
Because, Your Honor, the IME which came and stated that the low back was not related or was never related comes 3 years after the initial injury. The carrier had ample opportunity to investigate, and they did investigate whether or not the low back was related. They had the initial Rothbard IME. And after that, we have the applicant in January of 2012 requesting a change of doctors, and specifically stating in his change of doctors that he's doing a change of doctors because of a need for spinal care. He's changing to a very well-known spine doctor, Dr. Terry McLean. And at that point in time, the carrier could have didn't even need a report. They could have come in and said, we object to this change of doctors, and we don't think that your client should be getting the spine care.
Counsel, let me ask you to follow up on Judge Catani's questions. You have described one view of the medical situation of claimant in this case, and what we're wrestling with, recognizing you're not claiming that he shouldn't have gotten benefits before January of 2014. The other side is claiming that he shouldn't have gotten them after that. And the question we're asked to decide is whether it was too late in the day to litigate that issue, whether that was precluded, right? That's one of the questions we're asked to address. And you've described the medical sort of overview, which is critically important. But what we're asked to decide is legally, was it too late in the day to challenge that? And Judge Catani had asked about what claim was it that was asserted, what litigation occurred, what contested adversarial something yielded an order that was so final it couldn't be revisited. And I think that's the legal aspect of that I'm at least struggling with respect to your client's position.
Right. So there's issue preclusion and there's claim preclusion. And issue preclusion is not what we're saying happened here. We're saying that it's claim preclusion. Claim preclusion is something that could have been litigated. And so what we're saying, what I'm saying is that the claim preclusion applied initially when at the outset, when the IME was done with Dr. Rothbard. At that point in time, had Dr. Rothbard not come down in favor of having the back related, or had the adjuster decided to send him for a second IME at that point in time, because maybe they don't see the connection between the low back and the knee, they could have done it at that point in time.
But it makes sense in terms of not letting them go backwards, maybe, and saying, gee, you can't now come in and say, my client was never entitled to something. But that's different than saying we've litigated, or there's some determination that we can't say prospectively the degree of impairment is an issue that we're entitled to now litigate. So I guess it goes back to that same question. Without having had some sort of litigation, it's hard to see why the commission would be precluded from saying prospectively, we now have new information, and this is a basis for us to say that we think this is the limit to what should be paid on this claim.
Right, but the problem is that if we were talking about what's being litigated, then we would be looking at issue preclusion. This is what could have been litigated, and it could have happened back at the beginning of the case.
You're suggesting the commission should file a lawsuit in each case. It seems rather unworkable, and it seems like the current procedure works to the claimant's benefit if they're willing to pay it, unless some new information comes out and they go into court. The typical scenario would be if it's paid and there's presumably the medical evidence will continue to support the claim. But it seems like you're hypothesizing or you're suggesting a system that would be very litigious and would not ultimately benefit claimants.
Your Honor, the other point that you could look at which there was something done in this case that triggers claim preclusion was the point at which my client filed the change of doctors. That very easily could have, that's my client stating, I need spinal care. It's unequivocal. I need spinal
Want
care.
the commission to come in and object to a request for a change of doctors?
Well, the carrier has the right to do that. The carrier has, it states on the notice of on the award, which allows the change of doctors, it states anyone who has an objection to this, you have 10 days to file an objection. At that point in time, the carrier could have come in, instead of acquiescing, they could have come in and said, we don't agree that he needs spine care.
But what if you need some, but then there's just ultimately a disagreement as to how much? And are you saying they can never come in and challenge how much is necessary?
No, Your Honor, that's not what we're saying. And they actually did get a second IME right around the time that my client did the change of doctors, and that was Dr. Mokzinski's IME, which doesn't say anything about causation, but it does say that my client was entitled to continuing benefits. Had the, we're looking at at this at the end of the case. Dr. Sanjay Patel, who is my client's treating physician in January of 2014, releases my client with substantial impairment, 19% impairment to the low back. The carrier issues a notice of claim status based on that impairment. They were. And that didn't go final because, the applicant did go ahead and protest that notice of claim status because he needed additional care, not because he was objecting to the, to the underlying, acceptance of to the back claim itself.
When he files that objection, if there's further medical examinations and something surfaces that everybody agrees that he had a brain tumor that's caused an impairment somewhere, is the carrier forever precluded from ever looking at the new information that came out that said, no, this condition, turns out it's related to something else? Your client was the one who challenged the award, and so presumably at that point, if there's discovery and if you want to develop that case further, why is the carrier precluded from considering or presenting new information that's developed at that point?
Because in this case, Your Honor, the way that this particular case was fleshed out was that Dr. Maxwell wasn't getting additional information such as what you're describing. He's looking at the information that was available at the beginning of the case 3 years later and deciding that the applicant never had a back injury. There's not a new condition that comes into play.
Counsel, let me ask you, what's the strongest published opinion under Arizona law supporting your case?
I would submit that it's the Aldrich case, Your Honor, and the reason for that is the Aldrich case states that where there is, if I may grab a different.
Of course.
The Aldrich case discusses claim preclusion, And finally, at the end of the case, indicates, and I'm going to quote it, to avoid the practical difficulties of litigating the question of compensability years after an alleged industrial injury, we conclude that preclusion must apply to informal acceptances of no time loss claims. Now, it's talking about.
And I was going to ask, because that is a no time lost, and it seems to me, and believe me, I do not claim any expertise in no lost time claims, but that seems to me that the process and the procedure for such a claim is very different than what we're talking about here. Would you agree?
It's different, but it's analogous. And the reason I say that it's analogous is because the no time loss claims, it's an informal acceptance. This is the same type of thing because at the point in time where my client is getting his, he's getting the knee treatment, this doctor comes in and says, oh, he needs back treatment. At that point in time, I submit to you that counts as a informal acceptance of that body part.
And I understand your position on that. Let me ask you one last sort of policy question. Wouldn't the consequences of adopting your client's position in this specific case result in a great number of sort of earlier upstream challenges to compensability? I mean, in other words, one way to look at this case is issue 1 is compensable. Individual has issues with issue 2 that may or may not be. Employer provides benefits for both issues 1 and issue 2 for a period of years, determines whether rightly or wrongly that there's stability, discharge, and then is found to not be able to challenge the compensability of issue 2. To adopt your rule, wouldn't carriers and employers say, well, look, we're not covering issue 2. There's no way. And, to tee it up for an adversary hearing early on as opposed to getting, somebody like your client services, even if it may, be beyond the obligation of what's required.
One theme that I've noticed in a lot of the cases that I researched for this for his case was that investigation was an important theme. Whether or not the carrier had the opportunity to do an independent investigation. In this case, the carrier had the opportunity to do an independent investigation. If the carrier, if that Rothbard IME had come out that the low back was an issue and was not related, there would have been a notice of claim status issued at that point in time, and that would have generated the litigation that you're discussing.
And I guess my broader question is, doesn't the rule that you advocate, not in this case, but in the next case, mean Mr. Chavez wouldn't receive any benefits absent a contested hearing for back pain, whereas here he received them for, 3 years?
That would be the case if the independent medical examination doesn't state that there's a relationship between the low back and the industrial injury.
Well, it's even more than that. If there's not a finding, right, that there's a connection between the two, right? Because if in other words, it's not going to be, well, we're not sure, but we'll provide these benefits. It's a, nope, we're not providing these benefits. So the only way to get them is to go to a hearing and say, hey, are these compensable or not?
Well, and there, just I suppose, Your Honor, what my point is that there's a point at which where the carrier should be held to the investigation that they've done. Had they not done investigation and just arbitrarily stated, no, we're not going to allow for the client to have this treatment and just, cut him off, at that point in time, the onus is on the client to get an IME or get some kind of opinion that states that the low back is related. Thank you.
Isn't your point, though, that it's better to have litigated it then than now?
My point is that if it was going to be litigated, it should have been litigated at the outset of the case because, in all fairness to the client and to memories and it would have been better to have this particular issue be settled at the beginning of the case. Thank you.
May it please the court. I am David Earl of the law firm of Cross and Lieberman. I and my dancing hand, courtesy of Parkinson's disease. I believe that one point that I need to make is that it was suggested that Dr. Maxwell didn't have up to date. Dr. Maxwell had every medical report that I had, and I tried to have everything from the very beginning right down to the last one before Dr. Maxwell saw him. So I don't think it was a matter of Dr. Maxwell not seeing the whole panoply of the records. I think the argument with regard to memories being old, this is unfortunately built into the system. If a case goes compensable and I appeal it and it comes up to this court and it gets set aside and it goes back down and it's going to go to hearing, then I'm going to hear from the other side about faded memories. If you reverse the situation, it's going to be me complaining about faded memories. I don't think that's just sometimes when you have an appeal, a passage of time is going to be built into the system.
Isn't the focus when the petitioner files a challenge, when the case is being closed, the focus is on the current condition, saying my condition hasn't resolved. So I'm not sure there's a loss of memory is that significant under, if the question is, has the condition resolved or what's the level of impairment? That's more of a current issue than what happened initially.
I agree. And it's appropriate, I think, within the system to identify the time of closing the case as medically stationary, with or without permanent impairment, and if so, to what part of the body, is an appropriate time to assign finality with regard to conditions, save and except for reopening type situations. And that's what happened in this case. It was closed even with the permanent impairment to the back, suggested by Dr. Patel. But they requested a hearing, and that puts all things in issue, and that's when I got rolling. And basically, I communicated to them as we were going about the preparation for litigation. I do not believe this back has ever been really picked up by the carrier knowingly, and I'm going to get an IME on the question. I got an IME on the question. I informed them that was going to be the position in litigation. And at, I think, several points during the taking of testimony, Judge Nye went out of her way to inform counsel, I believe I have the right to not be foreclosed as far as liability by the payment of benefits that have gone on.
Well, counsel, why, when the treatment goes beyond what the original claim was for, why wouldn't a carrier step in and say, wait a minute, we agree to pay for this one injury, but this other injury goes beyond the claim. Why wouldn't they want to resolve that earlier rather than later when the case is closed?
I set forth a series of those reasons. More than anything else, it's that you have sketchy facts, things haven't been drawn clearly. Sometimes a carrier is simply picking up some medicals that they know the claimant's going to have, even though they may think it's not related, just because they're trying to keep the wolf from the door. More than anything else, it's just I think it was in the fourth of these cases, Walsh, of what I called the boilerplate cases, which talked about with the press of all the time that goes on and the press of business, sometimes things don't get focused on. But I believe completely that what you were suggesting in your questioning was correct. If you do it the way Ms. Melendez wants to suggest it should be done, you're going to get a whole heck of a lot more litigation all up and down the line. And if the carrier has taken the position that we don't ask for the benefits back, we just ask for a chance to be heard on the question of whether or not the low back is related, and to that extent, the judge agreed.
Let me ask about the notice of change of doctor. What's your response to that?
I think you need to look at it for what it is. It's got a 10-day fuse on it instead of a 90-day fuse. It's straightening things around on the on the desk more than anything else. It's the ICA needs to be informed of who's actually doing the treating. But here again, if you made it definitive, the change of doctor order as to what conditions are related to the industrial injury, you're going to end up with a whole heck of a lot more litigation than what has been found to be the law currently, which sort of lets things go along. At any point in time, Ms. Melendez could have done a request for hearing under 1061J to basically say he's not being paid for this, he needs to be paid, and it would have cleared the decks for wanting to make this happen. At any point in time, the carrier could have, by one, like they've talked about issuing a notice that limits liability, they could have, but they didn't. The question is, what's to be done in cases where they don't? If you say, well, we got to do a whole heck of a lot more to regulate this, you're going to get a whole heck of a lot more of litigation. And I think it's especially under an administrative distribution of benefits system such as the workers' comp system, where you've got bifurcated hearings going issue by issue, then in that circumstance, the nature and extent of res judicata and its progeny, call it by what name you please, is going to constantly be before the courts of appeal and the judges. And if you start saying, that's why I've got a pretty much a general theme in my brief that there's no action or inaction by the carrier, even with a lot of claims processing, that should be deemed to be dispositive with regard to the question of the low back.
Well, and I guess along those same lines, even assuming your client had decided to litigate at some point, if there's a finding that the back is related, that doesn't necessarily mean that there's a finding of the extent and the permanence of the injury. Correct. So you would have litigation, but you're still not foreclosing future litigation.
That's correct. You'd probably be just deciding the question of Dr. X wants to treat and says the low back is related, and you litigate that, and if that becomes the finding. Now, sometimes we all agree that the nature and extent of that finding, Dr. X recommends a 2-stage surgery or something like that. You know, if Dr. X is allowed to become the treating, there's going to be an unscheduled permanent come out of it in a low back case. That's just built into the factual fabric of the situation. But as a general rule, there have been plenty of cases that I have had where it's just been Dr. X, the low back, and eventually they go on to have as good enough a recovery that it can be a no permanent case.
I guess your opposing counsel has suggested the problem here is now there's a finding that it was never related at all. Does that change your analysis at all?
Not to my mind.
If they had said it's a 1%, then it goes down this path I've been suggesting. Okay, well, there was an agreement that it was 1% responsible, but that doesn't go to the severity. But does it matter that it's 0%, that it wasn't related?
Not in my analysis. I don't think it makes a difference, and I don't know of any case that suggests if Judge Nye is going to make a decision like that. It never was. It nevertheless contains within it, because they allowed some treatment over a period of years, there must be some element of permanency. I don't know of any case that says that.
I guess maybe there would be preclusive effect in terms of if your client were trying to recoup some back payments. Is that?
I really think, I don't know of any case that addresses that, and I agree that would probably be a new ball of wax. I agree. I bet you get a lot of people say, I had something on my mind that I've forgotten, but it's past. I think that, especially when you read what I have never organized a brief along the line of here's a boilerplate paragraph from the judge's decisions in these 4 cases, but it was really, I thought, a good way of organizing it. And one thing I note as I look over the facts of those cases is the length of time during which the condition was being taken care of, the cerebral hemorrhage and Noble, is all kinds of processing is going on, all kinds of time is passing, and nobody is alleging, wait a second, that is forecloses your ability to contest the question. And I think that's a good example of how that sort of thing ought to work under these 4 cases. If I may anticipate a question, I think Noble is the best case, and I have indicated in my brief, I think my reply brief, I don't think Aldrich should be, because when you look at the facts of Aldrich, they are trying to take it from a there is a claim to a there is no claim situation. Whereas what we did here was we litigated the extent of the conditions that arise from the industrial injury on an accepted claim. And that's a big difference. I have, if it's classically issue preclusion we are talking about, then the issue is actually supposed to be litigated out, and the determination needs to be essential to the award that is issued. Claim preclusion, I don't think that Ms. Melendez and I have ever really been in agreement as to what claim preclusion is and how it does or doesn't apply. My definition of it, I don't think it applies in any way factually to this case. But then I had a brief that involved a res judicata argument years ago. I found a quote, which was from some federal appeals court judge, that said, res judicata is everywhere universally respected, but actually not treated very well. Mm-hmm. And I remembered it as I was putting together this brief.
In your view, is there a difference between issue preclusion and claim preclusion?
Well, I thought claim preclusion is where you're essentially trying to make another claim altogether for what has already been filed as a claim. Issue preclusion focuses on the specific issue in question and whether or not it has been litigated. If, for example, I gave the example in the brief, if Mr. Ortega Chavez had decided to file a second claim for that date of injury, saying, all right, now I say I hurt my back in it, okay, I agree, that one was a leg claim. Now this is a back claim. That's when I think claim preclusion would apply. That's my definition, perhaps too restrictive, but that's what I think claim preclusion amounts to. Issue preclusion is issue by issue.
The first time you file something saying it's my knee, and you might have had some very minor back pain, but the back pain develops, he couldn't have come in and amended it and said, I also have
yes, he could have amended it. I'm talking about a second claim. That's what I think is precluded. He could come in. I return to what I said before about 1061J as a catch-all that is used by the claimant's bar to put into issue these sorts of things. It's done and it's used. It's a flexible mechanism. Are there times when we in the defense bar grit our teeth because of ways in which we think it may be asking for too much or going too far? But we litigate them out, and they have available that way of putting things into issue, and the carrier, if they want to put things into issue, has notices that limits liability, those sorts of things. What is at issue here is when neither side does anything like that, and time passes. I don't think the passage of time or the payment of benefits should make a difference. Can I answer any other questions of the court? Thank you.
And so, Your Honor, we're not saying that payment of the benefits is what entitles Mr. Ortega Chavez to additional benefits. What we're saying entitles him to claim preclusion is the fact that the carrier had the opportunity to do investigation, did the investigation, and in fact accepted the low back as part of the injury.
What if it just accepted that it's 1% of the injury? It's accepted it doesn't, there's nothing really to be gained by other than costing everybody some money by litigating, but they accept 1%. Why does that preclude them later on from saying the final award is adequate? He's not entitled any more than that.
And Your Honor, just to clarify what you're asking, are you saying the 1% at the end of the case, or?
I'm saying if just early on, if they just accept there's been an IME or a doctor who said there's arguably some injury to the back as well as the knee, and if the carrier just agrees that there's some, we're not agreeing that it's a major injury, but fine, there's something, and we're going to make payments with that understanding. Why does that preclude them from coming in and challenging the severity of the injury?
And that would have been a different scenario, Your Honor. At the end of the case, we wouldn't have been litigating whether or not there was ever an injury at all. We would have just been litigating extent of injury.
The same thing, though, as saying if you're saying the severity isn't as great as you're suggesting it is, because we now believe that it really wasn't related at all, that to the extent there's an injury that it was caused by something else.
There's a difference because Dr. Maxwell is going back and he's not saying that. He's not, or I'm sorry, I'm not answering your question. There is a difference, Your Honor. You're correct. If the carrier at the end of the case is saying there's, that this is now only related to, maybe his arthritis, and it's not related to the fall. That would have been a different issue, and that would have been a different issue, and I wouldn't have been able to make the same arguments in that case. And I'm out of time. Thank you.
Thank you both for your argument. We'll take this matter under advisement and issue a decision in due course. That we're adjourned.